Welcome, everyone, and thank you for joining us for this presentation of the American Bar Association, Tips for Young Lawyers, Building the Framework for a Fulfilling Career. Now, we want to thank our sponsors, including the YLD Litigation Committee, Corporate Counsel Committee, as well as many others who helped put this presentation together. Now, today we have an exciting program together with you. We are joined by Paul Sandler, who is our distinguished speaker for today. He is a trial lawyer, he's a litigator, he's based out in Baltimore, Maryland, and he is a columnist for the Daily Record, where he provides periodic commentary and a column called Tips for Young Lawyers for a Fulfilling Career in the Law. Now, we are very honored today to have Mr. Sandler, as he is an author of The Anatomy of a Trial for Young Lawyers, as well as a litigator who is renowned around the country for his work in representation of defendants in criminal cases to plaintiffs in civil lawsuits, and including personal injury lawsuits, as well as con law, trial and appellate level included. He's also known for representing some public figures, including former Hillary Clinton campaign finance director David Rosen, as well as Viacom heir Brent Redstone. He has been described as a brilliant courtroom litigator, and he's been called upon by national media for his insight to discuss high-profile legal cases. You might have seen him on television programs such as Larry King Live, The Today Show, CNN Crossfire, as well as many others. Today, we are hoping to have a very candid dialogue, and please feel free to share any questions that you may have as a young lawyer as we discuss navigating a fulfilling career as a young lawyer. So to begin, Paul, we do want to ask specifically about your column and what you put out as one of the first tips, and that was establishing a career plan. Now, as a young lawyer, I can say that we do have a tendency to want to hit the ground running and get out into the work field, whether that is in private practice, if you're in public interest, or if you're in-house. So why is it beneficial for us to have a career plan at the outset? Can you explain why we need to have one and when we should develop it, whether that's at the first in the first outset, or if we should do that later on in our career?
Good question, and thank you for that introduction and the white lies you told about me, but let's proceed to get to the answer directly. In life, generally, many of us believe that a plan helps us focus and gives us the energy to proceed in a direction that we think will be fulfilling for us, whatever that is. Now, the practice of law, as everyone knows, whether you're a senior lawyer such as myself or a young lawyer, is really complex. It is so broad-based that it can be compared to perhaps large cities in the world, Hong Kong, New York, millions of people, millions of choices. And to move forward in life, a plan helps. You can measure your progress. We can measure whether we are satisfied. So because of the breadth and depth of law, it's really helpful as a young lawyer, in my view, to have a goal. What is it that you want to accomplish in law? Is it a part-time job for you, or is it a career which you want to, in some way, contribute and make a difference to the profession, to the society, and of course, importantly, to the clients? So if you have a plan, and let's just use a plan that I want to be a corporate lawyer and master mergers and acquisitions. Well, it gives you a goal. It also gives you a challenge. Well, how am I going to fulfill and succeed in my plan? And that could be mapping out for yourself over 5 years or 4 years, different steps that you want to take. For example, you may want to spend a year off and on just reading on the topic. Maybe you want to be an appellate lawyer. Well, it would be great to learn and study appellate law on your own, because no matter what plan you have, the most influential, I believe, control of succeeding in the plan is you, not someone else. You have to work. We as individuals have to be responsible for developing ourselves. And now, unlike when I started practicing law over 45 years ago, there are so many sources that you can resort to learn and to read. Reading books on appellate practice, how to present an effective oral argument by judges and appellate lawyers, mastering the topic that fits in with your plan It's a very healthy way to go forward as a young lawyer. And you have to devise your own plan. And then sometimes as you go forward, it gets, you change it, you reevaluate, and you realize this is the direction I want to go. So I'm assuming that everyone here, and I should say generally a greeting, hello, young lawyers, wherever you are. I'm sure that you wouldn't be listening into this program if you didn't have a desire to succeed as a lawyer for the benefit of clients and for fulfilling life goals.
That is absolutely correct. I could not agree with you more, Paul. And as part of that roadmap, I know your second tip to us was saying that we should consider having a mentor. And just kind of to, bounce back off of the career plan, first, why should a young lawyer have a mentor?
Well, in my view, one of the most important steps and initiatives a young lawyer can take, that our listeners can take, is to have a mentor. Someone, and I always have recommended, outside of your office, whom you admire. Perhaps it's in the field that you aspire to become accomplished in. And to have the opportunity to brainstorm and to talk to that individual and learn from that individual. And when you have problems, reach out to that individual. I know from personal experience that my mentor, who recently passed away, has been my mentor for as long as I've practiced law, even in my days of being a senior citizen. It was in his 90s, and he was, at the time he became my mentor, well known, perhaps one of the leading lawyers in appellate practice and trial practice in the state of Maryland. And there were more than 100,000 times I would call him, and he would render assistance to me. He would give me advice. He would even look over some of my early writings. He was a true mentor. If I had issues, without violating confidences, if I had certain issues in the office that I could share with him, I would, and he would give advice. I think it's indispensable for any young lawyer who has a real passion for the profession of law and wants to grow and succeed. I think it's really essential to have a mentor out of the office.
Specifically, you said out of the office. Is it possible, or would you recommend us having more than one mentor? For example, if you are in private practice, having a mentor who's in your firm, whether it be a partner or a senior associate, who can help you navigate, I guess, the political realms of the law and the business of the actual firm.
Well, I don't think there's anything wrong with that. I think you can have more than one mentor, because as we go through life, we have friends, we interact with many professionals, and you might ask advice of person one and person two. But for me, having one main mentor is enough, because that's a relationship, an investment, and the ideal mentor is someone who will take an interest in us or in you as young lawyers. So, for example, what would be the ideal mentor? Someone who's really prominent in their field, really has the personality and the interest in you, who will take you to lunch once a month or 2 months, who will take a call from you. And when I have a problem, so-and-so is really doesn't like me and giving me all the horrible assignments, and it's really getting me down. And having a chance to talk about that in private to someone out of the office is invaluable. That doesn't mean you can't have others, but my experience has been one great mentor is worth 10 others.
And I think that's a fair point. And to speak more about mentorship, I know you said one great mentor, especially someone who's prominent in their field. What would you say then to young lawyers, and this is something that I can speak to that I found common with some of my peers and myself, is to stepping outside of our comfort zone when it comes to looking for mentors. For instance, as a young woman, we might look towards, women who are seniors in their career as opposed to looking for a man. as well as in diversity, finding someone who looks different from you and just, taking that step outside of your comfort zone to find that person, regardless of what they may look like or how comfortable you are, just going up to them and asking them for assistance.
That's intriguing. My response to that is, as humanly possible, to strive for the level of excellence that you seek. And then once you achieve, say you have 3 or 4 lawyers that you think, wow, wouldn't that be great if I could talk to that person? Then you could isolate or refine it to where you have a comfort level. Because it's no pleasure or reward if you think mentor A would be great, but you just don't care for them, you don't respect them, or they don't have an interest in you. So sometimes you have to, you start with one mentor. Sometimes you may change. In my personal experience, the individual who was my mentor never even knew he was my mentor until after a year. I just kept calling him all the time. And as a matter of fact, all young lawyers have traumas, and I had a trauma when I was new to the bar, where I filed an appeal, and the Court of Special Appeals of Maryland dismissed it as untimely and sanctioned me to $50. You can tell how long ago this was. I won't give the year, but it was not quite prehistoric. But at any rate, I really panicked. I wanted to jump out the window. I thought this was the end of my career. So what did I do? I reached out for the lawyer that I really admired most as a youngster, and told him of my situation and asked him for help. And he told me he would help me. And he was on what we call the Rules Committee, which everyone knows was for the Maryland courts. And about 3 weeks later, the Maryland rules on appeals changed to accommodate my appeal. And then 3 months later, the Court of Special Appeals reversed the opinion and withdrew the sanction, which was laughable, I guess, if you were a senior lawyer then. But I was just out of law school, a year or two out. So, I'm giving a personal example of where mentors can really help. You have a trauma, you have a concern. A great mentor can give you advice, help you, let you see the right perspective, and he or she can be a guiding force through your career. And then, as you mature, friendships are born.
Thank you for that. And I think in terms of mentorship, this kind of brings me to your third tip. You said to conduct yourself professionally in the office. Specifically, I think in terms of what you just described, mentors can help you at least understand how you should be conducting yourself, whether that's in the office or outside the office. And I would want to, broaden that tip that you provided, discussing professionalism. But first, let's discuss in the office. What are some practical tips, at least for myself, it's been one of the biggest challenges that young lawyers can implement when taking on assignments that they may not necessarily have time to do. So are we ever too junior to turn down an assignment? Is that frowned upon? Is that unprofessional?
Well, let's put it this way. To go along, you have to get along. And in any office, in any environment, the culture of the office is crucial to your satisfaction. And different firms have different cultures. I mean, years ago, if you were in a college, there were fraternities, sororities, and they all had different cultures. Colleges may have different cultures. If you go to someone's home, there may be a culture this way or that. So the law firm culture is the overriding key to how one acts in an office in terms of all decorum, in terms of accepting work or rejecting work. So hopefully you're in an office or a government office or whatever, private office, where the culture is compatible. So what do I mean by culture? I should say that. By culture, I mean all the ways of thinking and doing, collecting that. That's the culture. So it's important, and when any of us go into a new environment, to listen carefully before we speak. So when you are interviewing, when you're thinking of changing firms, the culture of how one thinks, how one does things, how that coordinates, that's really crucial. So you have to. The first step is to learn what is the culture. What is expected of you, and certainly we hope in terms of professionalism that senior lawyers are going to be helpful to the younger lawyers and help them grow and develop so that usually there are assignments and sometimes you're in a group but you love to work with another lawyer. It's a question of balancing. And sometimes there are two concepts I wanted to share with you or ideas about work and assignments. Usually you as a young lawyer are assigned to one group or one or two different partners that would give you work. So that is an easy situation because you will be conversing with your partner, the partner, liking that partner, hopefully, who will have an understanding of what your workload is. So obviously, if you're going to be sitting in a deposition for 5 straight days and someone comes to you and says, I need this in 3 days, you have to defend yourself and your role at the same time, not insult. So you could say, wow, I'd love to do that. What should I do? Maybe you should talk to John, Joan, or whomever who wants me 5 days because I don't know how else I could do that. Or can we get a longer extension? Or how do you want me to handle it? So you don't have to say no necessarily. You could be diplomatic and say, I just really don't know. But the one thing I wouldn't do is just take the assignment and just blow it off, so to speak. You shouldn't do that. That's just discourteous. So there's no one way to do that. I mean, if you've been working for 3 years with the partner, know them well, you could say, Gene or John, I can't do this. I'm working on the brief that's due in 2 days. If you want to wait till I finish the brief, otherwise, what's your idea? Help me, so to speak.
And that sounds like what you're saying is professionalism. Majority of it is really just being responsive and communicating. So when something comes up, just letting whoever it is that's supervising you or whoever is asking the task of you to let them know what's on your plate, let them know what you're able to take on. And if you do take it on, you're not able to finish it timely, just letting them know ahead of time and being courteous. And that's the same thing as maintaining the professionalism within your career.
That's correct, but I want to emphasize, and I'm sure it's obvious, so maybe I shouldn't have to emphasize it, I'll just comment. Professionalism is more than just how we handle assignments. Professionalism is how we act in the office and out of the office, what our language is, how we comport ourselves, how we treat our assistants, how we interact with our colleagues. I pointed out not too long ago, half in jest, but still, I asked a young lawyer, so someday, let me know when he comes out of his office during the day to look around and see who's walking around and who's in the office so he could say hello and talk to them. Because I note sometimes many of us get so consumed in our work that we close the door and we get in at 8 in the morning, we leave at 6, and we work, but we eat lunch at our desk. We don't socialize or interact. And I think part of being a lawyer in an office is to benefit from the company and the knowledge of our colleagues and helping them out. I mean, it's not you may have a question, and it's not even unreasonable to ask a colleague. Judy, you've worked with John before. I mean, what type of structure does he like in these memoranda that I'm working on? That doesn't hurt. Just professionalism is to help your colleagues, help your peers, and to act civilly. And then outside the office, it's really important. Let me just acquaint you with, for a minute, everyone, what it was like to practice law in the early 70s when I came aboard. First, there were no books or writings to learn anything. You learned from the older lawyers. They would stop and take the time to help you. And you could walk outside your office, you could see Linda Marcus walking down the street, and you could say, Linda, I've got a family event this weekend. I need 5 more days to respond to my interrogatories. She would say, no problem. That was it. You didn't put it in writing. You didn't have to memorialize it. It was, to me, the emblem of professionalism, cooperating with other lawyers. We're talking about outside the office. it may sound unusual for me to say this, unusual to you, but one goal that I have when I'm involved in cases, many of them, which I always try to make the life of the other lawyer easier. I don't compromise my client's rights, but I don't. Typical example: a young lawyer comes to me and says, "Paul, I really have a terrific situation on my hands. I'm going to burn the other side." I said, "What do you mean?" Well, they filed a third party complaint. That means they brought in a new party. And when that happens, the lawyer is supposed to give the new party all the pleadings that have heretofore been filed. And this young lawyer is saying to me, and the other lawyer didn't do it, I'm going to get the case dismissed. Fortunately, he listened to me and followed some advice, which necessarily doesn't apply to everyone. But I said, you know what? This is a situation where you should pick up the phone, call opposing counsel, and say, I don't want to be presumptuous, but I have the third party complaint. I really think that you forgot to either comply with the rule or if there's oversight, but you didn't include all the other pleadings. So rather than file a motion to dismiss, how about you just send everything to me or refile with it? So young lawyer does that, comes back and says, wow, I did it, and they were really happy. Well, of course, wouldn't you want someone to do that with you? It doesn't compromise anything. All the judge was going to do is look at you, probably dismiss the case angrily because it was a wasted motion, and then file, leave to amend. So my point is, in discovery and in courts now around the country are developing preambles to some of the rules about the importance of counsel meeting, trying to work through difficulties. So I think that that's an example of professionalism. And certainly in depositions, deportment is important. Screaming and yelling is not acceptable, although it occurs. That's the point. All this occurs.
Now, in that same vein, with professionalism outside of the office and just the importance of civility, I really would like to speak about how and what we should do when it comes to being active within the profession. So how can young lawyers make time to attend social events or bar events, such as the one that they're sitting on now, but at the same time, when they have working obligations? For instance, if you're in private practice, you might have a billable hour requirement. Or if you're, in-house, or if you're in public interest, you might have, something that is pressing, the deadline that needs to be met. How do you find time, or how did you find time as a young lawyer to balance that? Because it is very important to get out there and attend these events, but at the same time, obviously putting work first.
Well, that is a very difficult problem because time is limited. Many of us have families, maybe young children, and lots going on in the world. So I'll go back to one of the earlier discussions we had about a plan. Incorporating in a plan, if you have developed one, should be, and we may get to this later, incorporating the concept that today the practice of law is not just a profession, it's a business. In fact, the Wall Street Journal refers to us as the legal industry. 20 years ago, they would refer to us as a legal profession. So we know that one route to success in the practice of law is eventually a young lawyer wants to develop business of her own or his own, because that helps growth and development. It's not the only key, I should say, because certainly the quality of work comes first. But in terms of answering your question pursuant to developing a plan, in any plan, I would think a role has to be specified at some point to interact and develop business. And how we do that is not that easy, but there are ways to plan for that. One, so let's assume that we're at practicing law for 3 or 4 years. We're developing this plan. I mean, the first concept might be to develop a feeling of real competency in my field. So I'm going to not only do my work, I'm going to find time somehow, some way, I'm going to work it in. I'm going to start reading what other lawyers say about how to write a brief, or what the key points are in developing a contract dealing with dispute resolution clauses, or in merger acquisitions or IP. What are the hallmarks of mastering this topic? And work in private time to self-educate. Also, I know that I want someday to be developing business. I can't do everything at once because the time is limited, but I will allocate in my plan limited time. So I'm in the city. I can join the city bar. I can join the state bar, and I can join a national bar, but I don't necessarily want to do it all the same day. I will slowly work my way through the various opportunities. So maybe I like the city bar, or maybe I like the American Bar Association Lawyers Division, but I will find one committee, one outside activity of the firm, and pay my dues. By that I mean work my way up to become a committee chair. I might write an article on a topic and make some suggestions. I might volunteer on a committee to help rewrite voir dire questions, or the real estate committee to try to work through some common issues of dispute resolution with agents and their clients. So if you look at everything all at once, there's a tendency to panic. Even today, when there's an overwhelming task, but break it down step by step and compartmentalize it and work out. So after a couple years, you're really comfortable in the state bar, then maybe you get active in the ABA and you do something. One good technique is to ask the partners that you're with in your firm, see who's active in what organization, and say, look, I'd be interested in getting involved. Can you introduce me? A mentor can do that. And that's how you can grow. You can't do it all at once, but you do it gradually, and it could be part of your plan.
I think you also just hit on our next topic, and I do want to circle back to it. Specifically, you said that we should make time to devote to developing our actual practice area and reading up on it, whether that's, appellate practice, IP. How do you actually make time to do this? So for instance, let's say I am a commercial litigator and I want to stay current on what trials are occurring right now within the Northern District of Georgia, or I'm a securities litigator or whatever have you. Are you saying that we should, in the morning or sometime on the weekend outside of the office, sit down and just actually stay current in terms of what's on the docket? Should we be reading, actual law articles? Specifically, what would you require of young lawyers to do to stay current within their practice area?
In my opinion, every lawyer, young and old, should keep current with the law and appreciate the nuances within their own domain or specialty. So independent reading and study is crucial. It also should be exciting for you because you're going to be improving yourself. Read all that you can, study, ask questions, call the authors if you have a difference of opinion, and engage. The first step in being a successful lawyer is developing an expertise in your field. But remember, as the old bard said, many a flower has shed its light on the desert sand, sight unseen. Once you have the beauty of your expertise, people have to know about it. And that's when the advantage of being active in bar associations. People get to know you, appreciate your work. They have a case or a commercial matter in your area, they give you a call. Tracy, Linda, I've got a matter, I need your help, it's in your jurisdiction, or what do you say? And that's how you grow. And in terms of developing the excellence, part of being successful means that you have a master of the topic, and then you can display that in the various organizations that you might wish to join.
What would you say to a young lawyer who might be in a particular practice area that they do not see themselves being in long term? Should they become a subject matter expert for the time being, even though that their career plan long term might say that they're going to do something completely different? For instance, if they're going to go from being an expert in a particular private practice area, but intend to be a generalist in-house down the road.
That's another good question, and it's somewhat individualistic in how one approaches it. But some very few areas of law are independent of other fields. I'll give you an example. Let's say there's a contract, and you're developing the contract, and then you need to have what we call dispute resolution clause. If differences arise and the parties cannot resolve their differences individually within 10 days, they have a requirement to mediate, blah, 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 and if mediation fails, arbitration. So you're a commercial lawyer, but if you don't know the art of dispute resolution and how it works in terms of where you go once you put something in an agreement, that you may end up going from a frying pan to the fire because you're not familiar with the American Arbitration Association rules. You draft in a way that doesn't comply with, say, the arbitration statutes in the particular jurisdiction. You could have a problem. So what I'm saying is that's just one example. If you want to be an expert in commercial law, that's great, but there's more to commercial law than just commercial law. You have to understand implications if there's a breach. You have to understand what the prohibitions are in terms of what you can actually put in an agreement. There's conflicts of laws issues. So the law is layered like an onion. You have to peel it away. You never really get to the center of it without appreciating it. So if you're in an area that's not to your liking, it's a stepping stone. It happens frequently. You have to start looking then to get either in your firm resituated, or maybe it's another firm. Maybe it's a government office, and that can happen. But I mean, it's not healthy to stay doing corporate law only if you really want to be a courtroom lawyer, for example. So you have to know when it's time to make a change, and that's where a mentor could come in by bouncing that off of her or him.
Absolutely. And to your point, in terms of actually becoming a subject matter expert, I know the next tip that you discussed is skill development and how we need to actually improve our writing skills, our oral advocacy. How can young lawyers implement ways to improve those skills? So should young lawyers focus on developing, for instance, their own style early on, or should they be adopting their style to conform more with the attorney that they may be working with? I know for myself, it's common if I'm working with a partner, I might look at briefs that he wrote or she wrote and conform my writing to their style or how they like to present their arguments. But if you're a junior lawyer, at what point do you then develop your own style and start implementing it without going too far outside the box?
I'm hesitating because to answer your question would take 6 hours, and we don't have that. So I'm going to try my best to be helpful. All right. Most of the writing we do as lawyers is persuasive writing, and there's an art to persuasion. There are techniques that are used. There are styles. There are skills. You can say the same for oral advocacy and written advocacy. I have as material to be distributed when this session ends an ebook that I recently released on persuasion in the courtroom, based on classical rhetoric and the modern lawyer, the art of persuasion. And I think if you read that and glance through these, it's a series of 5 articles over the years I've written. I think it will help you think about writing and oral argument and give you a lot of questions and ideas to pursue. Essentially, though, generally, regardless of how the style of a lawyer that you're working for is, there's certain fundamental principles of clear writing. And I think mastering those principles is a way to begin, and not, sometimes you might be writing a written brief, maybe a replying to a motion to dismiss, but basically keep in mind, as I'm learning today, People don't have a lot of time to read what you write. They want to get it quickly, get the answer, and move on. So there's a little knack to persuasive writing, and that is set forth what your goal is at the beginning. This motion followed by such and such should be dismissed for the following three reasons: A, B, and C. Paragraph, turning to the first reason, blah, blah, blah. This is why the case is such and such, sets forth the principle that governs this proposition. It's as clear as a fire bell in the night. The motion is just not appropriate even at this time, or probably not ever. The second point, so you're giving the introduction, you give a presentation, your argument, and a conclusion. We're not writing in legal memoranda the so-called O. Henry short story. For those who aren't familiar with O. Henry, he's a great author of short stories, but he had what was called the O. Henry surprise at the end. How you thought the story was going to end is completely opposite. So it was called the O. Henry surprise. There should be no surprises in legal writing. Bear in mind, it's really obligatory to invite the court's attention, and certainly a senior partner's attention, to case authority that is in opposite to what you are arguing, and then to explain why it differs. Your case differs. So, I mean, to say how to do an oral argument or written brief, it is involved in their techniques, and it's a lifelong journey. I mean, I still learn and hope to improve. But basically, if you're doing a memorandum for a lawyer or a memo, it's helpful to have a tight, written, clear articulation of what you want, saying at the beginning, stating the issue, giving the conclusion, and then the explanation. And I use a little thumbnail sketch sometimes in my arguing for a particular assertion, presentation, and conclusion. Assert the principle, present the reason, give the conclusion. Oral argument in each differs from court to court, but essentially the techniques of oral argument are unique to each individual, but there's certain key points. For example, if you're writing a brief or presenting oral argument, you really need to tailor what you're writing to the listener. You're doing a brief on search and seizure, claiming that there was an improper search because police climbed up a telephone pole on public land and then looked with binoculars into a house and saw drugs and guns. You may want to argue that was an invalid search. But if you were writing that brief to a particular judge who's written 20 opinions over 30 years on search and seizure, you have to tailor what you're saying to that individual. Like, that's always the case. So that's a first rule. Tailor your writing or your oral argument to the listener. Then what you really need to consider, this is important, the concept of ethos. Ethos is the I would say the listener's perception of your character as a writer. Who are you? And one way, and so that's what ethos is. It's the listener's perception of who you are in terms of the quality as a lawyer or a writer. And you do not want to write with ad hominem attacks on opposing counsel. You do not want to say that the argument presented by counsel is ludicrous, ridiculous, and attacked personally. It's unprofessional. It's not healthy, because you want to be respected for your writing, so that if you're going to, with your partner, if it's a memo, you want that partner or that judge or whomever to say, wow, this is from so-and-so, very good lawyer. I don't have to go and double check the facts in his case, or in his writing. So I talked about tailoring your argument to the listener, remembering your ethos and the style. You need to also consider the arrangement of your writing. The idea of primacy and frequency or recency is important to think about. You need to think about, you talked about style. Style are the words we use to express ourselves. So style is important. And in thinking about style, with the words we use, you need to consider schemes and tropes. What's a scheme? A scheme is the order of words we use to express ourselves. Or I'm sorry, a scheme is rearranging the order of words to express ourselves. Take Faulkner. He doesn't write, and as I lay dying, Keith was a good carpenter. He says a good carpenter was Keith. So you can play around with language. Repetition is another example of a scheme. Conrad, Heart of Darkness, horror, horror, horror is what I felt. I'm not saying you juice up your memos to your partner in a way that's silly, but I'm just trying to help us focus on the words we use. And of course, I talk about arrangement a lot. I mean, how you arrange your argument. I talked about that earlier. Primacy and recency are 2 points in arrangement. The first thing we hear, the last thing we hear. So those are some thoughts on style or on writing and oral presentation. Some of the articles I wrote that you'll read, if you would care to, will get into a little more detail.
We also spoke about this a little bit at the beginning, and you mentioned it, and it's our next topic. But you said that the practice of law is a business and a profession. What is one thing that you wish you would have known as a young lawyer that you know now about building a successful book of business?
Wow, that is a profound question when you think about it. What I didn't know that I wish I had known. I think that if I had known that law was really very much a business, I would have prepared a little earlier in my career relating to, I would say, networking and meeting people. And I don't think that's a problem today because I think it's apparent for every young lawyer when they go into a firm that in order to succeed, not in your first years, good firms recognize that as young lawyers, the first stage is to develop an excellence in the quality of their work, get known a bit for it, and then to spread out. But today, the bar associations, they'll even networking lunches. Okay, well, what's a networking lunch? To meet someone, just to go to the movies with? No, it's to cultivate friends, share your competency, and make acquaintances that can help you, not just necessarily get cases, but just in various aspects of life. I mean, you're a young lawyer today. Someday you may have a young person, a son or a daughter that's going to college. You may find that someone that you work with in the young lawyers division is on the board or something, or can write a letter of recommendation for you. I mean, networking is not just for law, it's just for life in general. That's how we make friends and grow. But I think it was never, when I started practicing, I remember the first position I had, the senior partner congratulated me and said, "Paul, this is wonderful. Now, if you want to make a lot of money, go across the street in real estate. You're in a noble, honorable profession." And if I had known that law was a business, I might have, just changed a little bit. But I think that answers your question.
You mentioned the importance of just getting out there, networking, but specifically such as, bar associations or sitting on the board of a nonprofit. How can a young lawyer use that at the outset of their career to build a successful career? So, for instance, something that's not time consuming, such as attending these meetings or attending, one event per month. How can they do that and use that successfully to build a book of business?
Well, that's interesting, but I think that the answer is not complicated. Sharing in one way or another without being offensive, the quality of what you do. Secondly, working hard in the organization in which you volunteer to demonstrate leadership and competency, which then gives the truth that if someone has a problem in your area, they've seen for themselves how you are attentive, caring, active, and sensible, and a good person. And then that's how you get called. If you're a trial lawyer and you win cases, people will hear about it. They'll call you. If you're a corporate attorney, you're in a committee. Let's say you're the state bar, wherever you are, has a real estate section, and you're active in that, and they hear you speak, they watch you, they see you, they know you, they'll call you. That's how it works. And of course, let's be realistic. Luck does play a role in it. Let's not be naive. I mean, a lot it depends on luck or just fortuitous circumstances. But I've always maintained if you grow to be an excellent lawyer in your field, word gets out. Word gets out. And if you're in community affairs, I think lawyers historically have been active in community affairs and boards. Just to give you an example, over all these years, I've been on probably 10 boards, and I usually stay for maybe 8 years, 6 years, whatever. But I'm always very active. I always pick a community organization that I really am interested in and can learn from. So it's been from hospital boards. Now I'm on a university board, and it's not just being there to have your name on the roster. It's to put your oar in the water and really make a contribution to the organization. And you will see that it's like throwing bread, I guess, out in the water. Some of it can come back buttered. I mean, you get known for being a sincere, good person, working hard. People will, who have a problem in your area, will call you. Sometimes they won't call, but a friend will say, "Do you know anyone that can help me? I've got this lease I got to develop, and I'm getting in trouble." And they could say, "I know someone," and it would be you. So it's a question of investing a lifetime in developing. This does not happen overnight. That's why I go back to the very first question. I have to have a plan. Where do I want to go? What do I want to do? And if you don't want a plan, you don't have a plan, maybe you shouldn't be practicing law. I don't know. Or maybe, and this is valid, you still don't know yet. There's 3 areas you like. That's fair. So then get yourself a kind of a timeline of when you're going to make up your mind. One thing is for sure. We must be decisive in the work that we do. Being a judge, being a lawyer really requires for decisions to be made, recommendations to be offered. And we can't be kind of indecisive and uncertain. We have to get to the point of making a commitment. So at some point, you just can't go 20 years not knowing which area of the law you want to practice in.
And I think to your point, a lot of young lawyers, particularly getting out there and just networking and meeting people, might not necessarily come naturally, but at the same time, also getting that necessary experience. So, for instance, excellence is the first thing that we need to maintain. However, if we're not, leading a case, or we're just, writing the papers and not necessarily getting out there for the oral argument or getting a chance to, close that particular deal, there's not an opportunity for us to present and hone on those skills. But I think one of your next points really allows you a chance to shine, and that's making time to give back in pro bono experience. So when should young lawyers start assisting with pro bono cases, and how can they use that to their benefit?
Well, first of all, pro bono cases should be for the benefit of the client. And doing pro bono work comes from the heart. And there are different ways of doing pro bono work. You could do pro bono work by volunteering for the legal aid and actually, I would say, like getting in the trenches. You can make a contribution. You could teach and give a lecture to the legal aid. You could write something for legal services. There's so many ways of doing pro bono work, from a soup kitchen position to anything. But I think that the heritage of the bar has been, for centuries, the willingness and the care for people that cannot afford lawyers. Now, there are institutions like the Public Defender, Legal Aid Bureau, that help indigents, but these groups can't do it all. That's why they'll allow you to be volunteers in the federal criminal courts. There's opportunity to be on a panel of lawyers to take pro bono criminal cases to help the public defender's office. So they're different ways and they're different times. Some firms encourage and will ask you to do pro bono work and give you time to do that. And I think that you can work a pro bono case in subject to your partner's approval when the quote right case comes, meaning a case where you think you can be helpful, and they will give you the time. Certainly, you're not going to do this without getting. If you're just starting out, you're going to get the approval of whoever supervising, and you can also, when you're interviewing for jobs or changing offices, if that's in your heart, you could say, what opportunities do you allow for pro bono? What does the firm do in that regard? You may be surprised. I say, you know what, we don't do enough. Come aboard, we'll help you. So it depends on what your schedule is and what the firm will allow and how involved it is. So those all come into play. And it's important to do, but remember, all that you're staring at through the window can't be accomplished in a day, a week, a month, or a year. It takes time. And the first, in my opinion, first objective, as we've stated, is to develop competency in what you're doing.
To our last point, and this is kind of going back to everything that we've talked about today, and that's, from a career plan, mentors, professionalism, subject matter expert, skill development. There's one kind of consistent underlying theme, and that is just honing in on professionalism, which requires us to also be very aware and knowledgeable of the rules of professional conduct. And I know we have the ABA model rules, but we also have jurisdiction rules that govern how we as lawyers should conduct ourselves. And particularly now, I read your article and I noticed that we discussed social media, which is another hot button issue, and we could have a whole nother topic discussion on ethics and how we should conduct ourselves, particularly with social media. But can you talk a little bit more about the importance of young lawyers reading these rules and knowing them for themselves rather than just relying on supervising attorneys?
Well, I think that you've hit on a very important point again, and I think that if you were going on taking a sailboat through the river, or if you were hiking on summer vacation, you would take it upon yourself to appreciate the surrounding environment. Where am I? What do I expect? Where am I? It's crucial to be current on all types of rules, including rules of ethics or professional responsibility. Familiarity with these rules is just indispensable. I think that let's assume, for example, you're an associate and a senior partner you're working on a case you can see is doing something, either intentionally or not, that violates the rules of ethics. We'll call this a subordinate attorney. She or he has an obligation not to go along with that, or will be equally culpable. So it's essential to bring it to the attention of the attorney. You don't have to be rude. By the way, Mr. Smith, you think this is right because my looking at such and such says it can't be done. And hopefully the partner, you're probably right. Thanks for pointing it out. The dilemma arises if it's really blatant and she or he doesn't want to go along. Well, you have some responsibilities. So that's just one little point. There's so many issues dealing with the behavioral conduct of lawyers that each state has its own rules. I mean, let's assume as a young lawyer, you're in a jury case and you want the judge to hold off voir dire so you can investigate prospective jurors on the internet. Well, that opens up a Pandora's box that we will not get into now, but from an ethical point of view, not being familiar with what the rules are puts you at a disadvantage. So what is my suggestion, because we only have another minute or two? My suggestion is that you, like I still do today, take time, read the federal rules of civil procedure if you're in trials and litigation. Read the real estate section of the state statutes if you're in real estate. Be current on the law. Read the newspaper of recent cases. try to get a feel. It's easy to do on the internet. The late cases, recent cases. Many jurisdictions have sessions at the end of a court's term of high impact cases of the 2018 term of the appellate courts. Try to go to one of those lectures or get the written material. Being current with the law is just as vital as knowing that the bridge that you're going to cross over that river swings very wide in the wind. So be careful if you're afraid of heights and don't want to be in that situation. We need to be current on the law. We need to do that because we have to be helpful to our clients and not put them in jeopardy. So I would take out those ethical rules, for example, and just take 10 minutes a day. I think that, remember what I said at the onset, we ourselves are our best teachers. We can program ourselves to get in a habit. Sounds silly. Take 10 minutes every Sunday and just read 3 or 4 rules or 3 or 4 ethical guidelines and move through it. Attend legal seminars. Keep ourselves current and informed in the law makes us extremely capable of effectively representing our clients in support of the rule of law and what we intend to accomplish when we hopefully went to law school and thought seriously about where we wanted to go and how we wanted to help people, because that's what lawyering is all about.
Well, thank you so much for
that. I want to give one concluding remark because I just thought of it. Absolutely. I think the goal of every lawyer, young or old, must be, as he or she works through the ranks of the profession, is to leave the profession better than it was when she or he began. And I think that is a noble goal, which has been stated, I think, over the years by others as well. It was a pleasure being with you, and I thank you. And is there anything further at this time?
No, I will say thank you for that. We did receive some questions. I'm going through them now, and please feel free to keep sending in questions. But one in particular, we have an attendee who asked, could you provide some advice for those that are in federal service as far as developing our career while working for the government to transition into positions in the future, such as in-house? For example, how can we take on pro bono cases if we're in the federal government to get that experience for in-house?
I think that in the federal government, depending what you're doing, it may be conflicted out. You'd have to go to an individual supervisor and not say, I may want to leave someday, but is there any opportunity to do either community service or pro bono work? Because it may be prohibited based upon the individual position. But I would say if you're in federal government and you're thinking of moving and changing careers, it's always helpful as a federal employee to be involved with non-federal lawyers in committees and community organizations, speaking and getting to know them, so that, well, let's assume someone's in the U.S. Attorney's Office and someday they would like to move. Well, we already have covered the idea of being excellent at what you do, but it would be nice to be courteous and friendly to lawyers in private bar. You could have lunches with them as long as it's not a conflict. You could go be on a charity board. You can get out in the community and get known. And then when you want to make your move, you could say, call up somebody, not somebody, but one of the people that you've befriended over the years and say, I'm thinking of moving here or there. What do you think? So I think if you remain in a shell, like most government, not most, but many government employees do, then you're cut off from the mainstream. And you're cloaked in your federal or state governmental position, but you're really not known outside of your little element. And the whole idea is to get people to know you and you to know people outside your own firm or your own governmental position.
Thank you so much for that, Paul. And I, again, want to thank you and all our attendees today that were able to listen in as we learned some golden nuggets from Paul Sandler. And we appreciate you taking the time, Paul. And we do have a handout for those who are attending. And this web conference will also be made available for those who were able to listen in, that you can also click on that and check out whatever Paul had to say that you might have missed. Again, thank you all for attending, and thank you to our speaker, Paul Sandler.
Thank you for being with me. Have a good day, everyone.